a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor. So I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
okay, you haven't started out well.
Sorry. I'm here because I'm told to be here today, Your Honor. That's the only.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this: you want to represent yourself in this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do that. That the court is going to hold you to the same standard the court would hold anybody else to, and the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
Notice how the judge is being incredibly thorough here. He's building a bulletproof record to ensure the defendant can't later claim his right to counsel was violated when things inevitably go sideways.
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until
suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened, I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda?
As you're calling it, your motion's denied.
Okay. Hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. Then you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass us to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
Here's a common mistake. People watch TV and think depositions happen in every case. In many jurisdictions, criminal cases rely on preliminary exams and discovery, not pretrial depositions like civil lawsuits.
So, this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that, as the court is well aware depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No, motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within
I really would be
grasp
objected
event.
Do you have a name?
His name is Jacob Spalding. I've known him for 15 years. I was with him throughout the course of the night, and
So you want his medical records?
I want to first of all subpoena him to get his witness statement on record officially, and I would also like his records due to the nature of why they.
I'm not going to order. I mean, that is. I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine. But I'm going to deny that motion.
Yeah, a lot of my civil procedures so that they don't.
The judge is explaining the burden of proof. You can't just say your rights were violated. You have to cite specific facts and law that prove the violation occurred. The defendant is struggling.
Hinder my trial experience, as I was not.
What does that mean?
Well, I was not given proper notice of my rights when I was detained, and I was questioned thoroughly afterwards.
You have to file a motion. You have to lay out specifics as to how and or another any statement that you made, which it doesn't sound to me like was the subject matter of necessarily an in-custodial interrogation, but it doesn't really matter. You're going to need to lay out all the elements of that before I would rule on that. But in its form and as it sits right now, that motion's denied without prejudice.
Thank you. My response to number 7, which is the defendant is notifying the court of.
That's what I was. Yeah.
So this last one, what are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work away. It doesn't.
Maybe that's the disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented? Fault, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I said is really all.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Your Honor.
Okay, so what are we going to do?
Well, I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not.
I need time to review.
What?
The judge isn't being mean here. If a defendant truly cannot grasp the reality of the proceedings, the court is legally required to pause and evaluate their mental fitness to stand trial.
What does that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them, Your Honor. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment.
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor. I mean,
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense.
About this case.
He doesn't want?
oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case, but I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Let me at least have some turkey before I have to deal with this again. December 5th. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure.
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make that is not sufficiently flushed out.
All right.
The defendant wanted his bond lifted to leave the state, which is the exact opposite of what bond is for. Bond exists to ensure you stay put and show up for your day in court.
To waive all bond conditions, leaving the state. And I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his phone. I will note it. I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office. So that may be something that I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of.
I believe it's the 911 call that brought the officers to the scene, but it would not be an exhibit that people plan on playing at the preliminary examination.
Else your request?
No, Your Honor.
All right.
That's fine.
With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. So the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate. Does not see an abuse of discretion regarding that. With reference to the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter and would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Fine for the, Your Honor.
Yes. So preliminary examination will be set January 21st, 2025, 9 a.m. before me. That's in person.